Imagine this. A company appoints a 75-year-old managing director. Is the appointment valid? Can a company appoint both a managing director and a manager at the same time? Can a person be appointed MD for 10 years in one resolution? And what happens if shareholders reject the appointment after he has already started working? Today, we will decode Section 196 of the Companies Act 2013 with practical examples, exam tricks, compliance requirements, and real corporate scenarios. Stay till the end because I will also share a quick memory chart that can help you score marks in CS Executive, CS Professional, and company law interviews. What is Section 196? Section 196 governs the appointment and reappointment of Managing Director, MD, Whole-Time Director, WTD, Manager. It prescribes eligibility conditions, maximum tenure, age limits, approval requirements, ROC filing requirements. Question 1. Can a company appoint a Managing Director and a Manager together? Answer. No. Section 196(1) clearly states a company cannot appoint or employ at the same time both managing director and manager. Why? Because both are involved in management and executive control of the company, the law permits either option 1, managing director, or option 2, manager, but not both simultaneously. Example: ABC Limited appoints Mr. A as managing director. Can ABC Limited appoint Mr. B as manager simultaneously? No. This would violate Section 196(1). Exam tip. Remember, one company, one chief executive structure. MD and manager cannot coexist. Question 2. For how many years can an MD or WTD be appointed? Section 196(2). Maximum term equals 5 years at a time. A company cannot appoint or reappoint MD, WTD, manager for a period exceeding 5 years at one time. Example: XYZ Limited appoints an MD for 8 years. Valid or invalid? Answer: invalid. Maximum permissible term is 5 years. Question 3. When can reappointment be made? Reappointment cannot be made earlier than 1 year before expiry of current term. Example: MD's term expires on the 31st of March 2030. Earliest date for reappointment, the 1st of April 2029. If company reappoints him in 2027, invalid under Section 196(2). Exam trick: 5-year term, 1 year early reappointment window. Question 4. Who cannot be appointed as MD, WTD, or manager? Section 196, subsection 3. The following persons are disqualified. A. Person below 21 years. Example: a 20-year-old promoter cannot be appointed as managing director. Appointment invalid. B. Person above 70 years. Now comes the interesting part. Normally, a person above 70 years cannot be appointed, but appointment is possible if shareholders pass a special resolution. Example: Mr. Sharma is 75 years old. Company wants to appoint him as MD. Can it be done? Yes. Pass a special resolution. The explanatory statement must justify why his appointment is beneficial. Question 5. What if special resolution fails? Important amendment. Suppose votes in favor are more than votes against, but special resolution requirement is not achieved. Then the board may apply to central government. If central government believes appointment is beneficial, approval may be granted. This is a favorite examination question. Question 6. Can an insolvent person become MD? No. An undischarged insolvent cannot become MD, WTD, manager. Reason: financial incapacity raises governance concerns. Question 7. Can a person who has suspended payment to creditors become MD? No. If a person has suspended payment to creditors or entered into composition or settlement with creditors, he becomes disqualified. Question 8. Can a convicted person become MD? Section 196(3)(d). If a person has been convicted and sentenced for more than 6 months, he cannot be appointed. Example, Mr. X receives imprisonment of 8 months. Can he become MD? No. Disqualified under Section 196(3)(d). Question 9. What approvals are required for appointment? Section 196(4). Step 1. Board meeting approval. The board must approve appointment, terms and conditions, remuneration through a properly convened board meeting. Step 2. Shareholders approval. The appointment must be approved by shareholders in the next general meeting. Step 3. Central government approval. Required only when appointment does not satisfy Schedule 5 conditions. Remember, Section 196 must be read with Section 197, Schedule 5. Question 10. What must the notice contain? The notice of board meeting or general meeting should disclose terms of appointment, conditions of appointment, remuneration, interest of directors, if any, other relevant particulars. Purpose: ensures transparency for directors and shareholders. Question 11. Is ROC filing required? Yes. Return of appointment must be filed with ROC. Time limit: within 60 days of appointment. Exam alert: many students wrongly write 30 days. Correct answer: 60 days. Question 12. What if shareholders later reject the appointment? Section 196(5). Suppose board appoints an MD. He starts functioning. Later, shareholders do not approve the appointment. Will all his previous acts become invalid? No. Acts already performed remain valid. The law protects actions taken before rejection. Private company exemption. For private companies, Section 196(4) and 196(5) do not apply, meaning shareholder approval and related requirements under these subsections are exempt. Government company exemption. For government companies, Section 196(2), 196(4) and 196(5) do not apply. IFSC public company exemption. Specified IFSC public companies enjoy exemption from Section 196 subsection 4. Memory chart for exams. 196 equals appointment of MD, WTD, manager. Remember, 21 equals minimum age, 70 equals upper age limit, 5 equals maximum tenure, 1 equals year before expiry for reappointment, 60 equals days ROC filing, MD plus manager equals not allowed. Conclusion. Before appointing a managing director, always verify age eligibility, insolvency status, criminal disqualification, maximum tenure, board approval, shareholder approval, Schedule 5 compliance, ROC filing within 60 days. Miss any one of these requirements and the company may face serious compliance issues. If this video helped you understand Section 196 in a practical way, subscribe to Corporate and Securities Law Compass for more Companies Act, SEBI LODR, and corporate governance content. Disclaimer. The content presented in this video is intended solely for educational, academic, and informational purposes. The views expressed are personal and do not represent the views of any organization, employer, client, regulatory authority, or professional body with which the presenter may be associated. The presenter is a member of the Institute of Company Secretaries of India, ICSI. However, this video should not be construed as legal, financial, tax, investment, compliance, or professional advice. Viewers are advised to refer to the Companies Act 2013, SEBI regulations, applicable rules, notifications, circulars, judicial pronouncements, and seek professional consultation before taking any decision based on the information provided. While reasonable efforts have been made to ensure the accuracy of the content, no representation or warranty is made regarding its completeness, accuracy, or continued applicability. Laws, regulations, and interpretations may change over time. The presenter shall not be liable for any loss, damage, or consequence arising from reliance on the information contained in this video. This channel does not promote insider trading, market manipulation, or any unlawful activity. All examples used are for educational purposes only. Copyright, Corporate and Securities Law Compass. All rights reserved.